Hello, aspirants. Welcome to La Excellence. Welcome to the session on Current Affairs for Beginners. In this session, I am going to tell you about the terms, concepts, schemes, and institutions that appeared in today's newspaper, that is 26th July 2018. Let me give you answers for yesterday's questions. The first question is, which high-level committee recommended a five-pronged strategy project, that is Shashakt, to deal with non-performing assets? It is the answer D, Sunil Mehta Committee. The second question is regarding Lokayuktas. They will be appointed by the President by consulting High Court Chief Justice and Leader of Opposition in State Legislative Assembly. This is the wrong statement because they will be appointed by Governor in consultation with High Court Chief Justice and Leader of Opposition in the State Legislative Assembly. So this is the wrong statement. It is not the President, it is Governor. And the second statement is Lokayukta was first established in Maharashtra in 1971. This is the correct statement. So the answer is B, only 2. The first article is Sabarimala ban not based on misogyny. In this article, mainly you have to see two articles mentioned on this and the argument based on these articles, that is Article 25 Clause 2B and Article 15 Clause 2. Based on these two articles, they have argued something in the Supreme Court, and let us see what is that. First thing is Article 25. What does this Article 25 in particular says? It says all persons, whether they are citizens, foreigners or non-citizens or residents, they are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion. That is right to profess. That is whatever religion they believe, they have right to declare that openly and freely. And the second thing is right to practice. That is they can perform any religious worships or they can perform any religious rituals, ceremonies or exhibit any beliefs and ideas of their religion. And the next thing is right to propagate. They can propagate the religion they believe, that is they profess and they practice. And based on this, and in particular Article 25 Clause 2 Subclause B, here you can see this says opening of temples to women in name of social reform and welfare. In this article, the argument is before, here there is a mention of word temples. That means it implies to Hindus. Before for Hindus, that is in Hindus, they follow casteism and they also follow untouchability and they don't allow these low caste people to the temples. So to avoid that and eliminate that practice, mention of this article and not in particular entry of women in all the temples, this argument argues. And the second thing they say about Article 15 Clause 2. Article 15 Clause 2. Article 15 in particular says that state shall not discriminate any citizen, remember it is citizen, on the grounds of religion, race, caste, sex or place of birth. There are these 5 grounds and based on that there should be no discrimination to any citizen, this Article 15 is saying. And here the argument is, you already know there is no entry of women in Sabarimala temple. They were saying this is a discrimination. But in this article, they argues that Article 15 says these 5 things based on the religion, race, caste, sex and place of birth, we should not discriminate. There is no inclusion of religious institution here. So, to this argument, they are arguing that so entry of women in this religious institutions is not mandatory. Try to remember these two arguments as 2 points which may useful for you in prelims. The first one is Article 25 Clause 2 Clause B. They argue this article in particular doesn't deal with the entry of women. And the second Article 15 Clause 2 Doesn't include discrimination on the basis of religious institutions as a prohibitory one. India proud to partner Africa. This article is important for us for GS paper 2, international relations paper, and this is India African relations. Our Prime Minister visited Africa, and here this statement is important for us, that is 10 principles for deepening India's engagement with the country, that is with the continent Africa. Of the times the statements of Prime Minister or President or Vice President or former Vice Presidents, they have given this formal statements as direct mains question. So here we have to see what are these 10 principles that are for the cooperation of India Africa. There can be question like what are the areas of cooperation between India and Africa, examine or explain or elucidate. So if you can remember these major 10 areas, then you can develop points on these 10 areas. The 10 areas are economic growth and fighting terrorism and extremism and climate change, cyberspace, and supporting the United Nations in advancing and keeping or maintaining peace, and maritime cooperation. See, Africa and in India we have large ocean here in the east of Africa, and in the west of India, that is Indian Ocean is present here, and there is lots of cooperation in this maritime zone. So maritime cooperation and in investments in industries, whether we can invest in this African continent or they can, mostly here it was said investment in African countries by the Indians. And the next thing is digital revolution or digital literacy. In digital we can cooperate each other. And the next thing is improve delivery of public services in Africa. We can help them in improving the delivery of public services, because our public service delivery is one of the most successful program in their country. And in education, health, in Africa's agricultural improvements, and in financial inclusion, how to make a financial inclusion in the Africa and how to mainstream the marginalized. In these areas, both the countries can cooperate with each other. Scheme must cover child abuse victims. Here there is a scheme mentioned, that is compensation scheme for women victims, survivors of sexual assault, other crimes 2018. This scheme was proposed by National Legal Services Authority. But from prelims point, we have to see one point. This scheme doesn't include child. So now bench of judges are recommending to include this clause of child under this scheme. And there is also mention of this payment as a compensation to the gang rape victims or gang rape survivors and rapes and unnatural sex assault women. For this woman, they were planning to have a 5 to 10 lakh compensation, and from this, and for this woman they were planning to have 4 to 7 lakh compensation. Remember this point, up to now there is no inclusion of the clause child in this compensatory, that is compensation scheme 2018. The next article is minutiae of Rafale deal. This we can incorporate it in GS paper 3, science and tech. And what is this Rafale deal? This Rafale is a fighter aircraft jet that we are buying, that is our country India is buying from France through an agreement. And from prelims perspective, let us see some points. This is intergovernmental agreement. The first one is, this is intergovernmental agreement, that is between two countries, not between two private companies. And the second thing, they will give this jets in fly away condition, that is after everything done in their country, the final product they will give, that is ready to use one they'll give. And the third thing is 50% offset clause. 50% offset clause, that is if 600 crore is the cost of the project, 300 crore, that is 50% offset, 300 crore work should be given to the Indian company. And the next thing is, they don't transfer any technology regarding this fighter jet. They'll just give the fighter jet. And this is a government to government deal approved by Cabinet Committee. These are the 5 points you should remember. The first thing is intergovernmental agreement, and the second thing is they will give ready to use, that is fly away condition, and 50% offset clause is provided. And fourth one is this is approved by Cabinet Committee. And the fifth one is protection of classified information and material in the field of defense. Here it was mentioned protection of classified information and material in the field of defense. What is this means? This means there are some information they classify as classified information, and this should not be revealed outside through media or any other social networking websites. India's Magna Carta. This article is about 100th year of Montagu-Chelmsford Report. What is this report? And what are the other names of this report? And what are the provisions of this report? Let us see. And this topic is important in both GS paper 1, that is in modern India, we read about this report. This also important in GS paper 2, that is historical background of Indian Constitution. In both these papers and in both these topics, this report is important. And this Montagu-Chelmsford report is also known as Government of India Act 1919. Let us see what are the provisions of this. Britishers during their rule, they have not given powers of independence or any powers directly in 1947. Through process, they have given one power through acts. And through this Government of India Act 1919, they have given some powers, and this report is mostly on Indian constitutional reforms, and is mostly on the increased participation of Indians in the British Indian administration. That is, there are lots of Britishers in British India administration, but now after so much struggle, they have agreed to increase the number of Indians in this administration, maybe it in legislatives or maybe in any government employments. And this act also gives provincial legislatures the mantle of self-governance. See, then we have provincial states, princely states. What is this provincial states and princely states? Princely state means these states are directly ruled by the rulers or kings. But these provincial states are under the Britishers. Like states have legislative assemblies or legislative councils, they also have legislative assemblies then. And this act gives more power to this legislative assemblies for self-governance. And this act also allowed the creation of municipalities and local body institutions with sufficient autonomy to handle their local issues. What we have seen up to now, Government of India Act 1919, mainly it provides two things. First thing, self-governance for legislative assemblies. And the second thing, devolution of powers, like we have seen, creation of municipalities and local body institutions and giving the autonomy to these institutions. The same was written here, that is, this MCR report established the framework for devolution of powers, first thing, and for self governance. Here it also says this act is one of the earlier steps towards the realization of responsible government, and this report was also to elucidate the principle of accountable governance, and this how by governing or by directing the government of India must remain wholly responsible to Parliament. So here they have given the supremacy to this self-governance for this legislative assembly and devolution of powers, that is, powers are transferred from the center to the states or to the lower level. Here, like creation of municipalities and local bodies at the lower level, they were transferring the powers through this act. And it also says government of India is responsible to the Parliament. And this act also became the basis for the Government of India Act 1935, and this is one of the key principles of responsible government, self-governance and federal structure. We have seen how it became responsible government because this act provides the provision such that government of India should be responsible to the Parliament. So this act made a foundation for the responsible government. And the second one is self-governance. How? Self-governance for legislative assemblies this act provided. So this act also laid a foundation for the self-governance. And the third one is federal structure. This act created this local governments and devolution of powers. This act laid a foundation to this federal structure. What are the main important features or provisions of this Government of India Act 1919? Self-governance for legislative assembly, devolution of powers like creation of municipalities and local bodies, and Government of India is responsible to the Parliament, and it laid the foundations for like three principles, that is responsible governance, self-governance and federal structure. And this act also laid the foundation of Government of India Act 1935. Here I just want to say one thing to you. Anyhow, you'll have some information about this act in your reference books or NCERTs. But before going there, try to evolve as much as possible from the article itself. Now we heard almost 7 points regarding this Government of India Act 1919. So try to evolve from this article itself. From this last line, you can even write a mains answer, that is, Government of India Act 1919 can be worth calling this title Magna Carta of India. That is, whether we can call this Government of India Act 1919 with this title Magna Carta of India, discuss. Try writing this mains answer. Try to answer today's questions, and the first question is, which of the following statements are true about Montagu-Chelmsford report? It is a report on Indian constitutional reforms. This report established the framework for devolution of powers. And the second question is, consider the following statements. Article 15 clause 2 says no person should be restricted access to public places, and Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. Thank you.